My name is Joseph McDaniel, and I'm a bankruptcy lawyer in Phoenix, Arizona. And under the 2005 amendments to the Bankruptcy Code, I'm also required to tell you that I'm a debt relief agency. So, I'm a debt relief agency. Now that we've gotten that out of the way, I'm going to talk about some of the reasons you really want to list all of your assets in your bankruptcy case. A question I'm sometimes asked is, how will they even know I have this asset in my Chapter 7 bankruptcy in Arizona? They'll know because it's their job to know. Bankruptcy law unites virtue and self-interest in Chapter 7 bankruptcy trustees. They get paid more if they find more assets that are non-exempt, and that benefits creditors, because after payments of administrative expenses in a Chapter 7 bankruptcy in Arizona, the proceeds from liquidation of the non-exempt assets go to pay creditors. Putting it a different way, do you think trustees are motivated to find assets you don't list? Well, duh. They get paid more if there are non-exempt assets in your bankruptcy case in Arizona and everywhere else. This applies to a Chapter 7 bankruptcy. You need to list all your assets in a Chapter 13 or a Chapter 12 or a Chapter 11 bankruptcy filing as well. But the consequences differ when you list non-exempt assets in a Chapter 13 because of the different internal logic of a Chapter 13, ditto 11 and 12. And remember that exemptions don't apply in corporate bankruptcy cases in Arizona because only human beings get the use of exemptions. So let's go over it again. Bankruptcy trustees are as different from each other as all other folks are from one another. But unless you love risk, you should assume that your trustee is a direct descendant of Eliot Ness. And assume as well that the trustee will do some kind of weirdo electronic asset search of every body cavity you own, and that all your stuff will appear like magic on a list that he will compare to your schedules. Your used paper towel collection can probably stay off your Chapter 7 bankruptcy schedules, but your collection of historic quarters had darn well better show up. If it's totally worthless, and all reasonable people would believe that it's worthless, and it's not land or a car, maybe you can fail to list it without bad consequences. But if it's a worthless Ford truck, with no engine, no transmission, no paint, rusting serenely in the backyard with a market value of negative $400 to get somebody to tow it away, list it anyway. Because if the trustee looks at his asset search and sees that you have title to a truck you didn't list, and you explain that it's worth negative $400, he might not mind much, or he might not mind seeing that you lose your bankruptcy Chapter 7 discharge. When trustees are unhappy or they distrust you because you failed to list assets, that's a very bad thing. And it's their job to know when you fail to list an asset. So list your assets in your Chapter 7, period. Thank you very much.